I'm pleased to welcome all of you this evening to this important forum and discourse on the Security Offences Special Measures Act 2012, better known as Sosma, a legislation that the Malaysian government has intended to deal with the threat of terrorism. We are privileged to have with us today a panel of eminent speakers, especially Tan Sri Abdul Ghani Patel, former Attorney General of Malaysia, on his first ever public speaking engagement post-retirement. And we are also pleased to have Amir Hamza Ashad, a distinguished member of our, initially I said criminal bar, it's actually our criminal law bar. Ladies and gentlemen, the Malaysian bar has been supportive of measures to counter terrorism. However, the touchstone for all these measures are the overarching principles of the rule of law and our unstinting commitment to the values of our federal constitution. It has been our consistent stand that in facing the threat of terrorism, we do not and cannot sacrifice our way of life and compromise the fundamental liberties that are enshrined in the federal constitution. It has been our consistent stand that in facing the threat of terrorism, we do not and cannot sacrifice our way of life and compromise the fundamental liberties that are enshrined in the federal constitution. One of the goals of terrorism is to create fear, if not by military might, then by stimulating our fears. This is today a worldwide phenomenon that evokes a variety of responses. Thus, as a society, we have to be careful that new counter-terrorism laws do not grip and paralyze citizens into surrendering their civil liberties and allowing for or ushering in a police state. In the crafting of counter-terrorism laws, public trust and confidence in the state should not be eroded. It is therefore critical that any departure from accepted civil rights and key elements of our democracy be deeply considered, fully justified, and ultimately proportionate to the portended harm. We must guard against laws that overreach and lend themselves to abuse. These laws are the wolf in the sheepskin and can easily become political weapons in the hands of the state or executive that harbors authoritarian ambitions. Strong counterterrorism laws are justified where it can be shown that they will help to meet the threat of terrorism, and these laws must be drafted in such a way so as to have a negligible impact on fundamental constitutional freedoms. In this regard, as a minimum, these laws must guarantee access to justice and the right to counsel for suspects, the exercise of investigative powers consistent with requirements of fair justice, and the independent exercise of judicial power and discretion in accordance with the principles of the rule of law. Distinguished guests, the exigencies of the terrorist threat should, in the main, be dealt with by applying and adapting existing processes in our criminal law to terrorist cases. In other words, the solution does not and should not lie in fundamentally changing the principles that undergird our criminal justice system and the personal liberty of suspects in order to counter these threats. This approach would be in tandem with the position taken by various international organizations that have recommended that the fight against terrorism should be focused on the strengthening of a rule of law-based criminal justice system and promoting the rule of law and respect for human rights. In this regard, the International Commission of Jurists in their 2009 report recommended adjusting the ordinary rules of criminal procedure and evidence to the complexities of terrorist investigation and prosecution, while still building in a number of safeguards and protections. More recently, in September 2014, United Nations Security Council unanimously adopted Resolution 2178 of 2014, which emphatically provides that, and I quote, "Member states must ensure that any measures taken to counter terrorism comply with all the obligations under international law, in particular international human rights law, international refugee law, and international humanitarian law, underscoring that respect for human rights and fundamental freedoms and the rule of law are complementary and mutually reinforcing with effective counter-terrorism measures and are an essential part of a successful counter-terrorism effort, and notes that the importance of respect for the rule of law so as to effectively prevent and combat terrorism, and noting that failure to comply with these and other international obligations, including under the Charter of the United Nations, is one of the factors contributing to increased radicalization and fosters a sense of impunity. It is noteworthy that Malaysia became a non-permanent member of the UN Security Council on the 16th of October 2014. Malaysia has therefore a solemn obligation to abide by this resolution, which is a manifestation of customary international law that existed even before the passing of this resolution. Thus, Malaysia, as a member state of the United Nations and now a non-permanent member of the UN Security Council, should not honor its obligations under international law in breach by the crafting and implementing both substantive and procedural counter-terrorism laws that are inconsistent with its international obligations. Ladies and gentlemen, allow me now to touch briefly on the passage to law of Sosma. It was introduced by the government in June 2012 as a replacement to the repeal ISA 1960. At the same time, amendments were made to the Evidence Act 1950, the Criminal Procedure Code, and the Penal Code. In 2003, Part 6A of the Penal Code was inserted. All of these provisions, taken together, were packaged by the government in 2012 as our anti-terrorism laws. It is to be noted that Chapter 6A of the Penal Code provides for terrorism offences, and Section 4 of the Penal Code provides for extraterritorial reach of these terrorism offences. Now, Sosma was intended to complement the substantive legal provisions and predicate offences in our anti-terrorism laws by providing for A, limited detention of up to 29 days for investigative purposes of terrorism offences, B, special procedures for the trial or hearing of terrorism offences in court, and C, powers of wiretapping, electronic monitoring, interception of communications, and other forms of surveillance. Sosma was undoubtedly legislated for anti-terrorism offences. It may be noted here that another purported counter-terrorism law called the Prevention of Terrorism Act 2015, POTA, came into force on 1st September 2015. POTA has a rather wide and undefined scope, extending well beyond terrorism, and is really the much maligned Internal Security Act 1960 in disguise. Critically, POTA has revived detention without trial, which is immunized now by a widely crafted ouster clause to exclude any form of judicial review. Together with the introduction of POTA, Sosma was also amended to expand the scope of surveillance and information gathering. Distinguished guests, there are a number of troubling aspects to Sosma. I do not wish to deal with them in detail, as that would be transgressing into the domain of our eminent speakers today. But some of the worrying questions that I wish to place at the forefront of the discourse today are these. Sosma allows for an initial detention of 24 hours for the purposes of investigation, and the extension of the period of detention beyond the first 24 hours up to 28 days. This further extension period is to be decided not by a court of law, but by a police officer of or above the rank of superintendent of the police. There is therefore no judicial scrutiny or oversight here. The role of the investigation and decision to detain should not be made by the same authority, the police. There must be a clear separation of powers as between the executive and the judiciary in a serious matter involving the deprivation of individual rights and liberties. Then Section 4.3 of Sosma carves out the defense of political belief or political activity. Thus, no one is to be held liable solely for his political belief or political activity. However, under Section 412A of Sosma, the definition of political belief is limited to the expression of an opinion or the pursuit of a course of action made according to the tenets of a political party registered under the Societies Act 1966. Thus, organizations not registered as a political party under the Societies Act 1966 or not registered or not registered at all may be subjected to the wide powers of this section. Then the right to counsel. The right to counsel under Sosma may be delayed by the police for up to 48 hours under Section 5.2 of Sosma. This is contrary to the fundamental right guaranteed by Article 5.3 of the Federal Constitution that obliges the police to inform a detained person of the reasons of arrest and afford him right to counsel. And this delay of up to 48 hours would mean that a detained person would be unrepresented before a decision is made by the police to extend the detention. Sections 6 and 7 of SOSMA provide for interception of communication by the police and the attaching of the EMD, the electronic monitoring device, on a suspect. It is a matter of concern that these powers may be exercised at the sole discretion of the public prosecutor. The absence of judicial oversight, particularly in the cases of interception of communications, is a grave violation of personal liberties, as protected under Article 5.1 of our Federal Constitution. A case may be made for the use of such powers in terrorism-related cases, yet even in such circumstances, these powers must be exercised sparingly and should be as limited as possible to prevent abuse and made subject always to judicial oversight. This is to ensure that the authorization should be made by a neutral, detached judge instead of being decided by the officer handling the matter. Section 13 of SOSMA states that bail should not be granted to a person charged with a security offense. In other words, there will be no bail. The offenses under SOSMA should fall under the exceptions of Section 388 of the CPC and regarded as non-bailable, which means the court has the discretion to grant bail. Case law has shown that the act of committal to prison without bail pending trial is an exception, and SOSMA should not disregard the fact that this is an exceptional practice. And finally, Parts 7 and 8 of SOSMA. Part 7 of SOSMA attempts to exclude the application of the Evidence Act from SOSMA trials. The Evidence Act contains principles and rules that ensures fair trial. Thus, only relevant and material evidence would be admissible. Section 2 of the Evidence Act makes no exceptions for any particular law. Then there is Part 8 of SOSMA, which allows for detention of an acquitted accused person pending the disposal of the prosecution's appeal. Ladies and gentlemen, I now come to what seems to be the abuse or the misuse of SOSMA. First, the stats. According to available news reports, at least 197 persons have been arrested under SOSMA since its introduction to date. Two of them, Yasid Sufat and Hilmi Hashim, have been arrested twice. But the two recent arrest, detention, and prosecution of Dato Sri Khairuddin Abu Hassan and his lawyer Matthias Chang, a member of the Malaysian Bar, have brought into sharp focus the manner in which SOSMA can be misused. Dato Sri Khairuddin and Matthias Chang were arrested and detained under SOSMA on the 18th of September 2015 and 8th October 2015 respectively. It is reported that they were being investigated at the time under Section 124K, sabotage, and Section 124L, attempt to commit sabotage, both provisions of the Penal Code. Dato Sri Khairuddin filed a habeas corpus application, which was fixed for hearing on the 13th of October 2015. It was reported that Matthias Chang was about to file a habeas corpus application as well. However, before Dato Khairuddin's habeas corpus application could be heard, both men were charged on the 12th of October 2015 in the Magistrates Court for the offense of attempting to commit sabotage under Section 124L of the Penal Code. It has been alleged that the act of sabotage is in relation to the lodging of reports about possible corrupt practices with law enforcement agencies in 5 foreign countries: France, the UK, Switzerland, Hong Kong, and Singapore. That was purportedly intended to be a conspiracy to cause harm to the banking and financial system of Malaysia. If convicted, they could be sentenced for up to 15 years in jail. Both men applied to the High Court to challenge the case against them. The matter has since been transmitted to the Federal Court under a constitutional reference, and today we've heard that the Federal Court has sent the matter back to the High Court. It is perplexing that the prosecution would see this case as involving a security offence. Part 6A of the Penal Code was introduced to combat security offences arising out of acts of terrorism. An act to expose possible corruption within the corridors of government cannot, by any stretch of the imagination, fall under Part 6A of the Penal Code, and neither is it a security offence under international law. The charge against Matthias Chang attracts to us additional concern because he has consistently stated that his actions were in his capacity as an advocate and solicitor advising his client, Dato Sri Khairuddin. His arrest, detention, and prosecution are therefore a clear violation of the United Nations basic principles on the role of lawyers, which mandates that lawyers not be identified with their clients or their clients' causes simply by the act of representing them. It would appear that the chilling effect sought to be achieved by the authorities by Matthias's arrest is to discourage lawyers from acting for known critics of the government. There is another concern. Is Sosma being used to pierce the principle of solicitor-client privilege? It would be reprehensible and an abuse of the law if this sacred principle suffers under Sosma. The principle of legal professional privilege must remain inviolate and absolute, as it protects all information provided by a client to the lawyer for the purposes of legal advice or representation, whereby the information cannot be divulged by the lawyer to anyone unless the client waives the privilege. That's the high standard. The principle is codified in Malaysia under Section 126 of the Evidence Act for the purposes of proceedings, and it has only two limited exceptions that render the privilege inapplicable. Namely, one, any such communication made in furtherance of any legal purpose, and any fact observed by any advocate in the course of his employment as such showing that any crime or fraud has been committed since the commencement of his employment. These are very limited and narrow exceptions to this hallowed principle that applies to the solicitor-client relationship. The intimidation and harassment, arrest and detention of any member of the Malaysian Bar in the discharge of his or her duties or obligations for or on behalf of any client is to be condemned. Every member of the Malaysian Bar is obliged to and must be allowed to act without fear or favor in the client's interests, with due regard to the rule of law and the administration of justice. Sosma should not be used against any lawyer acting for and in the interests of his client. Distinguished guests and ladies and gentlemen, whatever the initial intention was to place Sosma in our statute books, today we must ask ourselves, particularly given the recent events, this very important question, and that's the question. Is Sosma a wolf in sheep's clothing? I have attempted to raise a number of matters in this speech that should be food for thought and ultimately for wiser minds to consider and deliberate upon. Thank you very much.